Welcome to the Libertarian Counterpoint. I'm Richard Field. On the program, John Cameron, the Development Officer at PLF and author of Rewire and Rekill. Damian Schiff, Principal Attorney at Pacific Legal Foundation. And we'll talk about some of the cases that he's working on and other people at PLF are working on right now. We're on the air on Channel 17 in Sacramento, on the web at accesssacramento.org. On cable channels all over the place, and eventually, wait a week or two, and on YouTube. Thank you very much for being part of the show. We'll get going here with the endangered species listing of the green sturgeon. What's that all about, Damian?
The green sturgeon is a species that inhabits a good portion of the west coast of the United States and all the way actually up into Alaska, but it's of concern to property owners because of the critical habitat designation that the National Marine Fisheries Service issued a few years ago for the green sturgeon. Now, for those viewers who aren't familiar with the Endangered Species Act, once a species has been considered eligible for listing, the government also has to designate habitat for it. And the idea is that the species needs this habitat in order to recover. The problem is that if your property is included within this habitat designation, it can impose significant restrictions on what you can do with your property, and therefore can impose significant costs and devalue the resources and other things on your property. Congress, recognizing that, amended the Endangered Species Act to give the government the authority to exclude areas from critical habitat if the economic impacts would be too severe. Unfortunately, the National Marine Fisheries Service and the Fish and Wildlife Service, who administer the Endangered Species Act, have used that power sparingly and oftentimes decide not to exclude areas, even where a very good argument could be made that the value of designating the area as habitat is not that great for the species, but the costs of doing so are significant. So basically, it's a cost-benefit analysis. We brought a lawsuit challenging the critical habitat designation for the green sturgeon. Bottom line is, though, the Ninth Circuit Court of Appeals held that we have no right to sue when the government says we're not going to exclude your property because of excessive economic impacts. Even if designation would cost $1 billion and would provide no benefit to the species, the Ninth Circuit still said you can get no judicial review, no day in court to challenge why the agency would do such an irrational decision. And so we have asked the Supreme Court to weigh in on that question.
Is the green sturgeon actually endangered? Is there a good argument to be made either on both sides of that issue?
I think it's fair to say that as a species, no. And it bears mentioning that here we're not talking about the entire species of green sturgeon. We're talking about just what they call a distinct population segment. So it's a tiny sub-portion of the entire species that's protected and for which this critical habitat was designated. I might mention that, talking about how significant these impacts can be, the service itself, the fisheries service itself, estimated that the annual economic impact of the original proposed designation would be over $500 million per year. And
the critical habitat that is so adversely economically affected, exactly where is that habitat?
For our clients, the most important areas are here in the Sacramento Bay.
Who are the clients?
The clients are the Bay Planning Coalition and the Building Industry Association of the Bay Area. But those are essentially larger associations representing individual property owners and industries who either have property along the shorefront in the San Francisco Bay Area or here in the Sacramento Delta, where habitat was also designated, as well as further upriver, say the Sacramento River, where there are a lot of water projects that now have had their operations burdened significantly by the restrictions that are attendant upon the critical habitat designation that goes up the river.
Isn't it also a lot of the coast?
It is, yes. In fact, actually it goes up in various portions through Oregon and Washington State.
So basically, if I understand it right, any kind of estuary area plus the shallow coast, or it's not shallow, but the near coast, all the way up the coast, and all the bays, and many of the rivers are part of it. It's like thousands, it was like 10, 12,000 miles of waterways or something when you add them all together.
You're absolutely right. But what's remarkable, though, especially about this case, and one reason why we filed the lawsuit originally, is that the service said that some of the areas we're designating are, quote, of high conservation value, meaning that they're so important to the fish that we can't do without them. And so we're not even going to consider possible economic impact exclusions.
And
What
where
are
are
those
those
areas?
areas?
Well, those areas are, for example, the entire San Francisco Bay.
The entire San Francisco Bay.
And yet
so
what's-
does this mean that you can't do any development essentially at all
Well-
in the entire or on the shoreline of the San Francisco Bay?
It gets worse than what you're suggesting, Richard, because notwithstanding that declaration, the service then decided to exclude areas for non-economic reasons. So, for example, some Indian tribes were able to get exclusions from the same high-value areas that the service said, you know what, this area is too important, so we can't exclude it because your business is too heavily affected. And so, essentially, that irrational decision-making was what precipitated our lawsuit. The government can't say to one citizen, we're not doing it for reason X, and then to another citizen, we're doing it for reason X. It can't be inconsistent like that. And yet, again, the
So
Ninth
this
Circuit...
is unequal protection of the law.
It is, and yet the Ninth Circuit said, doesn't matter what the reason is for why you're objecting.
So the Ninth Circuit is essentially deferring to the agency authority come hell or high water.
So, in fact, the deference is so great that it's really no review at all. There's no day in court.
Would you suspect from this that the placing this endangered species listing on the green sturgeon and calling all of this critical habitat is really simply a smokescreen for stopping all development in all these areas?
I think that explains why, for example, the Center for Biological Diversity, an environmental group that is very active in endangered species stuff, brought the original lawsuit that led to the listing of the green sturgeon and the critical habitat designation. This center and other allied environmental groups regularly use environmental laws for what I call pretextual reasons, meaning that they're not really so much interested in, say, the green sturgeon, they're more interested in stopping all the development that goes along with protections for the green sturgeon.
So the species protection is merely a means, and the end is to stop anything, any kind of development that they have a aesthetic objection to.
And we saw that most prominently, as I'm sure many of your viewers know, with the Delta smelt controversy. Same thing, where you had a fish of really no value being used as a way of trying to dramatically change land use in the Central Valley of California.
Now, the smelt case never made it to the Supreme Court. They declined to hear.
That is right, yes.
That particular case. Is this is a similar argument being made, or is this a different legal argument?
This, I would hope, is a bit easier to make, because in the smelt case, it ultimately was a question, whom should we favor? The fish and the environmental interests, or the farmers? Here, though, we're not even getting to that point. We're just asking the court, can we even have our day in court to make the argument? And that's an argument that even the more liberal justices on the Supreme Court have recently shown a little more solicitude for.
So I have a question. First, how do we get capitalists put on the endangered species list so they're protected? And then second, about the, it's kind of tangential to this, the Delta smelt, if you look back at pre-man, pre-civilization, probably even pre-Aboriginal man in the Delta, there were times when the Sacramento River, for example, went completely dry. The American River, completely dry. So the Delta, as we know it, is artificially maintained at a much higher overall level of water flow than it was periodically in history during other long droughts, because at least the American River, I know, would completely dry up, and I believe the Sacramento, turned the inner valley into a swamp in the wet, but it was in essence a desert in the dry. So how could this Delta smelt survive that but it can't survive the restricted water flows that are greater than that are proposed while still keeping food on the table of American citizens.
Well, that's an excellent rhetorical question, and it brings to mind, we've tried to argue in our litigation at the foundation in other cases where water districts are being forced to release water for fish purposes. And yet that's water that is only available precisely because of the reclamation projects
Because of the dam.
that are being attacked by the very environmental lawsuits that result in that water release. And so if it weren't for the project...
So they're trying to have their cake and eat it.
Exactly. And unfortunately, the courts until now have allowed them to do that.
Murr versus St. Croix County, Wisconsin. That's a case about having two lots, one of which you can develop and one not. Why?
There is a basic principle in takings law meaning the law that comes from the constitutional protection against your private property being taken without just compensation, that if the government says you can't do anything with your property, if it regulates your property to the point that there's no value left, it must pay you compensation. Whereas if it just regulates down to, say, 10%, the government has a much stronger argument for not giving you anything. And so as a consequence of those bright line rules, it's critically important for property owners to be able to show, hey, look, I can do nothing with my property, you must compensate me. Because of that, though, governments have always been keen to try and argue, no, you still have something left in your property pile, so to speak, and therefore we don't owe you compensation. And the Murr case is relevant to that because in the Murr case, our clients, they purchased two lots in the 1960s along the St. Croix River in Wisconsin, a beautiful vacation spot. They built a cabin on one, left the other lot vacant, zoning changed, and ultimately they were told they could never build or do anything with the adjoining lot. Now you would think that...
But pay taxes on it. They had to pay taxes as if they could do something.
That is true, and that unfortunately is an injustice that always occurs in these cases. But when they said, well, look, we can't do anything with this other lot, it has no value now, aren't we then entitled under these rules that I mentioned to compensation? Because we can do nothing with it, there's no value left. And the government responded by saying, well, there's only nothing left if you consider it in isolation. But if you combine it with your adjoining lot in which you already have a vacation cabin constructed, it no longer has no value. It has some value, and therefore we owe you nothing. The Wisconsin courts agreed with the government in taking that position, and the Supreme Court has taken up the case, which will be heard in October. Now, the court decided to take up the case before Justice Scalia's death. And so now we have a 4-4 court that will be addressing the issue, and presumably the case will be a little harder to argue than it was before Justice Scalia's death. But nevertheless, I think the basic fairness principles involved here, that it shouldn't matter that your lot just happens to be next to another lot that you own, as to why you get nothing, and somebody else who owned the same lot would be compensated. That basic injustice, I think, will attract some of the more liberal members of the Supreme Court.
Now, I heard the phrase relevant parcel bandied about, which to me is insane. And as I understand it, if you own 3 parcels and one is 100 miles away and 2 are right next to each other, then they'll call the one next to yours in this area a relevant parcel in that pile of property that you talked about and prevent you from. And this kind of injustice happens 100 times, 1,000 times a year throughout the U.S., whereas the one that's 100 miles away, they can't make that case for. Why don't they just extend it to ad absurdum and say, well, if you have 10 properties, no matter where they're located, we're only going to let you develop one?
Well, I'm sure the government would love that, and I think it underlies a reservation that some of the more liberal members of the judiciary have had about takings law, that we shouldn't be compensating wealthy people, that somehow the right to compensation is in part a function of how badly you need the property that was taken. And the idea is, well, if you've got 2 lots, you must be, or 3 lots, you must be wealthier than if you only have 1 lot. And so we're going to be less willing to compensate you.
But they don't say that.
No, they don't say that, but it's definitely implied in their analysis. Now, I think the best answer and the one that I hope the court adopts is the lot independently marketable? Or is it just simply a property owner trying to game the system and saying, well, I'm going to divide up my existing lot into 1,000 mini lots, and then I have to be compensated for all the mini lots in which I can't do anything? That's not what's happening with the Murr case, and that rarely happens in any case. That it's just simply the market recognizes that this is a marketable lot. It's subdivided that way under state law as well. It should be treated as its own lot, own property for purposes of these compensation rules.
Of the 4 or 5 liberal justices, 4 liberal and 1 swing, who do you consider to be the justices that will vote the correct way on this case?
Certainly, the Chief Justice, Justices Alito and Kennedy and Thomas, I think, will likely vote for us.
Okay.
For the right result. And I wouldn't be surprised if, say, a Justice Kagan or a Justice Breyer, who have shown some desire or some interest in a middle ground, I think, on a lot of these controversial issues. I wouldn't be surprised if maybe one of them might also be at least sympathetic.
Mm-hmm. White versus the Voluntary Interdistrict Choice Corporation. This is an interesting case. It's out of St. Louis. It's a case where a kid, black kid, lived in the city of St. Louis and is attending a charter school where he's doing very well, and a charter school where he would like to stay. However, he's living in a bad neighborhood, a rough neighborhood, and his mother decided, I think we need to move to a suburban location. We need to move out of the county. But I'd like to keep my child in the same school. It, after all, is only 10 minutes away from where I work, so therefore I'd like to move to the county and continue having my kid go to the charter school where he's thriving. The voluntary, I think I like that word, Voluntary Interdistrict Choice Corporation says, no, you can't do that. What in the world is that all about?
It is remarkable that you could have in this day and age essentially a government entity that's saying that a black child cannot attend a school because he's black. But the problem here is St. Louis used to be, by law, a segregated town in terms of its educational opportunities. And in the late 1970s, a lawsuit was filed to end that explicit racial segregation. The federal district court entered a settlement, a consent decree that said that, okay, we need to impose these racial rules for the time being so that we can undo the racism that has gone on. And the problem is that the corporation you mentioned that now covers the districting in St. Louis still thinks that it's 1980, and that for whatever reason it still has the authority to impose these remedial rules about where whites and where black kids can go to school, because at one point there was a need for it to remedy explicit discrimination. Obviously, this is not 1980, and there is no reason to discriminate against a black child in wanting to go to the school of his choice.
And the school of his choice, as I understand, is 80% white at this point.
It is, and so ironically, it would in fact increase diversity to have him to continue to attend the school that he wants to attend.
And the reasoning behind the original settlement or whatever was that St. Louis majority black, St. Louis County majority white. Therefore, we'll only allow white students to transfer into the city. We'll only allow black students to transfer out of the city.
Right.
Not the other way around, in order to manufacture or compel racial diversity.
And even more strongly than that, it was because the city had been consciously discriminating the other way for a long time. Mm-hmm. And so it was a necessary interim remedy to counteract the effects of that expressly race-conscious decision-making.
Now, correct me if I'm wrong, it would seem to me that under the terms of the original settlement, that the parties, the members, the superintendents of schools that constitute the Interdistrict Choice Corporation, probably don't very much like what they're having to do to this kid. And do they welcome the lawsuit as a way of forcing them to do the right thing?
Well, I would hope so, but the reality is that the district was, or the corporation was well aware of this issue before we filed the lawsuit, because our client's mother had made her opposition quite vocal. And she was told repeatedly by the school district officials that too bad, so sad. So
That was the official memo.
I think it was, and yet it's still inexplicable to me why the relevant officials would not have seen the injustice of this. So,
well, but were their hands tied legally? Where they may have wanted to do the right thing, but would have put themselves in legal jeopardy had they done so?
It's hard to imagine what jeopardy they would have got themselves into by allowing a black child to attend the school of his choice.
Okay, so my theory that they're hoping to be told to do the right thing is bogus?
Well, I mean, government officials, even if they know the right thing, oftentimes don't do it for inertia reasons, if for nothing else.
Okay.
That may be going on here, but ultimately, there's no serious concern that they're going to do anything wrong.
What's the legal argument for changing this? It would seem to me that it's a bona fide legal settlement that they have to live under. What's the legal argument for making a change in it?
It is true that if it were a settlement that had no continuing effects, then it would be a different issue. But this is an ongoing program. It's not as if we're challenging the effects of something that was long ago decided. It's a program that's being administered every school year and processing new applications all the time. So because it's still operating, it can't hide behind a shield of, well, this was decided 30 years ago in a lawsuit.
Isn't this agreement is redone every year, isn't it? Or every
Essentially,
few years.
and that's
so
part of why
they
the settlement doesn't really
readopt
work.
the stupidity over and over and over again.
Thus allowing us to bring the lawsuit.
Okay.
Well, good luck. Next one. This is an actual win, I guess. Johnson
It
versus
is.
EPA. Tell us how that came about and the precedent that made it possible.
Well, it's another unfortunate abusive story of a property owner by the federal EPA that thankfully has ended well for the property owner. Andy Johnson, he and his family own about a 10-acre parcel or so of land in Wyoming. He built on it a stock pond. The purpose of the stock pond was to provide, as stock ponds normally do, to provide a clean water source for the livestock and horses that he had on the property. Before he did this, of course, he obtained a stock pond permit from the state of Wyoming, followed all of the requirements of that permit, and he thought he was in the free and clear. After doing that, though, he was issued a compliance order by the federal EPA. EPA saying, you're violating the Act, the Clean Water Act, because you didn't get a permit before doing your stock pond construction. Now, the remarkable thing is that the Clean Water Act expressly exempts the construction of stock ponds from any permit requirements. So you ask yourself, well, why would EPA even bother to issue this compliance order telling him you're violating the law, you've got to change what you're doing? And the answer is EPA thought, well, because he must be doing it for other aesthetic reasons, because he likes the ornamental value of having the water there, that means it's no longer a stock pond, which I think to me and to Andy Johnson and to most Americans would be ridiculous. Now, you mentioned, well, what happened next in terms of the precedent that allowed him to sue EPA. It used to be the rule that you could never sue EPA when it issued one of these compliance orders. In 2012, though, PLF won a case called Sackett v. EPA in which the Supreme Court said, yes, you can sue. So relying upon that precedent, we filed a lawsuit. Shortly thereafter, EPA realized, hey, this is stupid, and I'm happy to report that the agency successfully agreed to settle the case with our client, and now Andy Johnson basically has the right to maintain his stock pond free and clear, no need to get a permit in perpetuity.
And with the due modesty, you are the person who argued Sackett versus EPA.
Yes.
Yeah.
Thank you.
Good job, Damien.
One of my few victories.
But when
No,
you have
we-
them in the Supreme Court,
They
that's
count.
quite the victory.
Well, the Tin Cup LLC versus the Army Corps of Engineers over permafrost wetlands. That's your case too, right?
It is, and it's another Clean Water Act case. This one is interesting because, you know, so often nowadays with the Clean Water Act you talk about whether your wetlands are jurisdictional. But this case concerns just, well, what is a wetland? Now, the Army Corps of Engineers has had a regulation for about 30 years that provides a definition of what qualifies as a wetland, and therefore what potentially the Army Corps can regulate under the Clean Water Act. But this definition isn't particularly clear. And so the Corps issued a manual in 1987 giving additional guidance. But a few years after it issued this manual, it started changing its rules, and it became very difficult for property owners to figure out, well, now, wait a second, is this a wetland or is this not a wetland? The Congress then got involved and issued a law saying that the Corps must use its 87 manual. Now, what does this have anything to do with Alaska, where we filed our lawsuit? Well, Alaska, as many of your viewers know, is primarily a state composed of permafrost, which is just another way of saying frozen ground. Yet, remarkably, the Army Corps, in contradiction of this 1987 Wetlands Manual, has been asserting Clean Water Act jurisdiction over permafrost throughout the state of Alaska.
So they're calling ice water.
They are, and that's really the nub, because even if you think wetlands should be regulated under the Clean Water Act, the values and functions that normal wetlands provide are not what permafrost provides.
Which is basically cleaning water. They're called
Yeah.
the lungs of the earth, wetlands, proper wetlands, whereas frozen ground can't perform that function.
Absolutely. And that's why, both as a policy matter, setting aside even the legal question that Congress said you cannot regulate permafrost because you have to follow this wetlands manual, we think combined make for a strong argument as to why the Corps' practice in Alaska is bogus.
Well, I understand the practical reasons why calling ice a wetland that can somehow or another cause pollution is silly. What's the legal argument for that you're making?
The legal argument is that for a wetland to qualify as a wetland under the wetlands manual that we've been talking about, there has to be a growing season of a certain length. And
Not much grows on permafrost.
precisely. And so and so it's really the reason why we think it's a clear case legally too that this permafrost rule is bogus.
Well, thank you very much. That's the show. We'll see you again next week, same time, same place on the Libertarian Counterpoint.